colleague going back to our days together in Brussels in the end game of the Uruguay round.
I was going to say also there's a material outside, which you probably already have, concerning small makers.
The steel retaliation is a horse of a different color. Again, the retaliation can be on products unrelated to steel, but here there's, as Ambassador Weeks properly points out, a very sharp division of opinion about whether it is legal under WTO rules to retaliate without the EU first going back to the WTO, as they've actually sought to do, and getting a judgment that the safeguard action taken by the President was improper. That's a very open question as to whether it is, and it's an open question as to whether they can unilaterally retaliate without going through that process.
Or shoes or any other types of goods, and in the end,
in my judgment, it would be important to have that kind of misunderstanding determined by a panel rather than unilaterally determined by one of the parties. This is the great strength of the new WTO dispute settlement system, is that you can have issues decided by a panel in an objective fashion rather than on the basis of the exercise of power. And it's a little unusual, I think, that the European Union, which very often accuses the United States of resorting to unilateralism, would find itself in the position of deciding that it may well go ahead and unilaterally interpret the meaning of this WTO provision.
That there is a genuine desire to come into compliance, and the real issue there